Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about credibility and argument before the jury. I'll have more in just a moment. Anytime an advocate gets up in front of a jury, whether it is in jury selection, opening statement, or closing argument, he puts his credibility on trial along with the facts of the case. If you can't trust the attorney to tell you the truth about what happened in a particular setting, then you are very unlikely to vote for his client. That's particularly true in the civil case, and it is particularly true in the criminal case as well, where the state is the client. If I go make an opening statement and I say I'm going to prove 5 things, A, B, C, D, and E, and I take that to the jury and I say, at the end of this trial, you will see that the evidence establishes A, B, C, D, and E. And then when I go through my evidence, putting on witnesses, I don't establish E. Well, at the end of the case, E is going to get dismissed if it's a separate charge, and that's exactly what happened in the Rittenhouse case. They never established that the gun that he was using that night was a short-barreled rifle. And as a result, they pretty much have to admit that they overcharged him, and that is good dismissal that the judge did because the evidence did not support that charge. So the first thing that Mr. Binger did in his opening statement was talk about how Kyle chased these people down and shot them. And that did not happen. He could never establish that. And given the intense amount of publicity this event had with it, and the opportunity prior to trial for all of these jurors to have witnessed this video, and whether they would have admitted it or not, I can assure you that 1 or 2 of them certainly did before the trial witness the video. Everybody knew as soon as he showed the video that Kyle did not chase down anyone. So there's your first strike as to credibility. Then you have all of these other things that the state did. They told the people that Grosskreutz was not at fault and that he was blameless and that he was surrendering, had his hands up when he was shot. And of course, the video didn't establish that. And he had to testify under oath that, yes, I didn't get shot till I pointed my gun at him. In closing argument, they made the most ridiculous argument I have ever heard, which is you don't have to be afraid of a little tiny Glock. By the way, a Glock 27, which is what Grosskreutz had, is a .40 caliber weapon, which is about twice as big as the .223 in terms of bullet size that Mr. Rittenhouse had. Right? You don't have to be afraid of that .40 caliber bullet that's twice as big as yours because you've got a big, scary black rifle. Again, this is Wisconsin where they're trying this. People own rifles there. You might get away with that in New York City where people don't have the right to own those kinds of things. But you're not going to get away with it in Wisconsin where people own and use firearms. And in spite of the very clear evidence in the case, the prosecution just kept digging itself a deeper and deeper and deeper hole. And then at the end of the day, they put on, the rebuttal was put on by the second prosecutor, who's sort of a large guy. I've seen a lot of references to him as Fatlock. And hey, I'm a little overweight myself, so I don't necessarily think it's a good idea to poke fun at people's weight. But the bottom line is, he was even worse than Binger. But the one thing that Binger did that was worse even than Mr. Klaus's rebuttal was he picked up an AR-15 and pointed it at the jury. He pointed it at the jury. Now, on October 27th, I believe, or 26th, there was a shooting in Santa Fe, New Mexico. You've probably heard of it. It involved Alec Baldwin. It also involved a, quote, unloaded gun. Except, guess what? The gun wasn't actually unloaded. And as a result, one person is dead and another person was wounded. The reason the rules of gun safety exist is because Murphy's Law is the only law you can't appeal. And as sure as you are that something is unloaded, you are apt to find out that it is not. I myself, as a young man, bought a hunting rifle. I bought a .243. It was a bolt-action rifle. It's very easy to check and see if a bolt-action contains a round. You simply pull the bolt back and push it forward to determine whether or not you have a round in the chamber. I had not put that gun away with a round in the chamber. I was firmly convinced of that, so I saw no need to check it. And guess what? There was a round in the chamber. And fortunately, it went into the dirt and nobody got hurt. But I myself have had a negligent discharge. I'm not perfect. And that was really good to happen to me at the ripe old age of 18, because from that point forward, I understood just exactly how bad a thing confirmation bias is. Confirmation bias is where you tell yourself that something is true irrespective of whether it's true or not. Because you believe it, you tend to think of it as true. And in this particular case, it wasn't. Well, when Mr. Binger got up and pointed that weapon at the jury, I can pretty much assure you that there was no way that a live round could have gotten into that courtroom and into that gun. And I'm sure Binger knew that too. But the bottom line is, you never point a gun at anything you don't want to destroy. And the other thing is, you always keep your finger off the trigger. You index it along the side of the weapon. And the classic way that gun people refer to that is to keep your booger hook off the bang switch. Binger's booger hook was his finger on the trigger. He had his finger directly on the trigger when he was pointing that weapon at the jury. And if you treat all guns as loaded, no reasonable person would ever do that. If you absolutely positively wish to destroy your credibility, there is no better way than to do exactly what he did in this case, which was to point the weapon at the jury. So we'll see how the jury comes out. I would anticipate an early verdict and an acquittal. The prosecution has done a terrible job. Their case completely fell apart. Mark Richards did a workmanlike job on closing, and I think it was, in all respects, I think it was a reasonably fair trial, but for the actions of the prosecution team, which I believe were way over the top. And I am still evaluating whether or not I'm going to file a bar complaint in that case, because a lawyer is under a duty never to make a misstatement of fact or law to a tribunal. And that's pretty much all the prosecutors did in this case. So we'll see how this turns out. Success has 1,000 fathers and failure is a bastard. So let's hope we have 1,000 fathers to thank for the result. Thank you very much for watching. If you found this interesting, I'd really appreciate a thumbs up. And if you haven't already, go over here and subscribe to our channel. Touch on the notification bell so you can be notified anytime we release a video on this channel. Again, thank you very much for watching. Leave your comments down below, and I'll catch you on here next time.